All right, so President Trump announced it in all caps last hour on his Truth Social site. He says, I have just signed the bill to release the Epstein files. That sets the clock ticking on the 30 days that the Department of Justice now has to release the files, but are they really going to be made public? Will they somehow be blocked? Joining us live now is former federal prosecutor and legal analyst, Neama Rahmani. Neama, good to talk to you again.
Brian, great to talk to you too. Big day for survivors of sex abuse.
It really, really is. This all just came down it was quickly. This whole thing. I mean, yesterday it went to the House, the Senate. The president now has signed this. This is it. Where do we stand at this point?
So politically, obviously, rare moment of bipartisanship there in Washington, D.C. Just one member of the House, Clay Higgins, no vote unanimously in the Senate. And of course, the president signed it today. But here's what I want folks to know. Legally, right? The legal application is very different from the political one. The Department of Justice at any time can release the Epstein files. They hold the privileges, and there's 3 privileges that apply. First is a law enforcement privilege. We've heard that. There's a pending investigation. Second is the deliberative process privilege. That means even if an investigation is closed, they don't pursue it. They don't have to disclose that. And last is the executive privilege, which folks know about. So Pam Bondi could have released the files already. So now that Congress has required that they be released, the question is, will the Department of Justice now assert these privileges, try to block the files from being released? And then, of course, a judge, Article 3 judge, will have to decide between a dispute between Article 1, the legislature, and Article 2, the executive branch.
And I think that's what people are worried about, Neama. Are we actually going to see this? Okay, so they're supposed to release these in 30 days. Are we going to see it? Are there going to be names redacted, which I think there probably will be? I mean, are we going to see pages of nothing but, black ink across sentences?
So if the Department of Justice chooses to comply with the Epstein Files Transparency Act or on their own release the files, there are 2 categories of information they cannot release under federal law. Doesn't matter what Congress says. Doesn't matter if the DOJ wants to do it. Can't do it. The first is grand jury materials. Those are secret. They're sealed under the rules of Criminal Procedure Rule 6. The second is information that identifies victims of sexual assault or sexual abuse. Unless those victims choose to waive that privacy, it's not going to be produced. But expect to see a lot. And the reason I say a lot, Brian, is if you look at the correspondence, the arguments, the filings in the Ghislaine Maxwell criminal case and the Virginia Giuffre civil case against Prince Andrew, the lawyers were talking about terabytes and terabytes of data. So there's a lot of information out there in the Department of Justice's possession, video, FBI interview notes. Some of it may be redacted, but certainly when it comes to witnesses, other perpetrators, that's not protected. So if the DOJ is going to really produce the Epstein files, all that information should be there.
Yeah, I think that's what most people want to see. Who are the names? Who were the ones that were involved in all this? I think that's the main thing that people, they want to see, and they want people held accountable for that too.
No question. Here's the important thing to note about accountability. I know people want prosecutions, and there should be prosecutions, but when it comes to a criminal or civil case, the evidence has to be admissible. So why am I saying that? Just because the FBI interviewed someone and they told them they were sexually abused by Epstein or others, that interview doesn't come into evidence. That's hearsay. And even if it did come into evidence, the confrontation clause of the Constitution requires an accused to be able to cross-examine their accuser. Why am I saying that? For there to be a prosecution or even a civil lawsuit, there needs to be a living, willing, and able victim that's going to come forward and say, hey, I was abused by someone other than Jeffrey Epstein because he's dead, or Ghislaine Maxwell because she's in prison. There has to be a living victim who's willing to come forward and accuse someone who has not been prosecuted so far. So if I'm reviewing the Epstein files, that's what I'm looking for.
It is complicated. All right, real quick, Neama, are we going to see anything before Thanksgiving, do you think? I mean, that's less than 2 weeks from now.
I would be pleasantly surprised. Let's color me shocked if we get the Epstein files before Thanksgiving. Let's not forget Bondi, Patel, everyone. They've been promising these files. I expected them earlier this year. So if we ever get them, I will be very happy. Look, I think it's important for transparency as well. You make promises to the American people. You should deliver those promises if you're an elected official or appointed by someone who is.
100% agreed. Thank you so much. Appreciate your time. Federal prosecutor, legal analyst, Neama Rahmani. We'll be right back.